Hello all, welcome back to Metis IAS. So, having understood about the provisions of this anti-defection law, let us try to understand the purpose of this anti-defection law. What exactly is the purpose of this anti-defection law? What exactly this anti-defection law tries to achieve? The first thing is political stability. That is, it ensures the stable governments by preventing legislators from switching parties for personal advancement, ministerial positions, or financial incentives. That is, as I told, let us assume there is a political party. There is a political party that it has just cross the magic number. I gave you an example that in a state X, where the magic number was 200 or the strength of the house was 200, and a party has to get at least 101 to form the election. Let us assume one party has 105 and the other party has 95. Okay. Now, if 10 people are jumping from the ruling party to opposition party, what it means to the ruling government. The ruling government will collapse. So only this anti-defection law can ensure stable government by preventing the legislators from switching the parties. For what reasons? For personal advancement or for ministerial positions or even for financial incentives. Okay. So this is the main purpose. The second purpose is democratic integrity. That is, it upholds democratic foundations by preventing defections that undermine voter mandates and create governmental instability and accountability gaps. Now, what it means, now again, as I told that in India, when the people of our country vote a candidate, primarily it will be based on the party that candidate is contesting from. If the same candidate is contesting as an independent, the chances of winning will be very, very, very less. But if the same candidate is contesting from a particular party, then the chances of winning that election is very high. Which means the voters in India are generally voting not for the candidate, but for the party, but for the political party. Now, when this is the case, after winning the election, if the representative switches from one party to another party, then what will happen to the mandate of the voters, or what will happen to the voter mandates or mandate of the people who elected this particular candidate? Their trust will be betrayed. So, in order to uphold the democratic integrity, the anti-defection law becomes very, very important. Another very important thing, or the next purpose of this anti-defection law, is upholding or ensuring party discipline. That is, this anti-defection law maintains cohesion within political parties, ensures members align with collective decisions and electoral commitments made to the constituents. That is, they make sure that the members of the political party or the representatives of the political parties either swim together or sink together. Now, there is a downside to it, but we will discuss this downside later. But for now, it is very important to understand that the political party invests a lot in a particular candidate. They send their star campaigners to ensure that this particular candidate is winning. They ensure that this candidate gets a ministerial berth or good positions in the government. Now, when that is the case, then in return, they also expect these representatives to abide by the decisions of the political party. So, to maintain cohesion within political party and to ensure that the members align with the collective decisions and electoral commitments, anti-defection law becomes very, very important. Another important purpose of this anti-defection law is the reduction in the corruption. Now we have seen the horse trading. What is this horse trading? This is a term that is used for those people who switch party from one party to another party. We generally see this horse trading soon after the election when the government has to be formed. Now, why this horse trading does happens? This horse trading happens mainly in the name of money. Mainly in the name of money. So, if there is something called as anti-defection law, this anti-defection law significantly reduces the political corruption by eliminating the incentives for party switching based on monetary inducements or power positions. So, for these particular purposes, for political stability, for democratic integrity, for party discipline, and for the reduction in corruption, anti-defection law was brought in the year 1985. Now, now, how these defections are going to impact the political system, how the defections are going to impact the political system. The first thing is defections subverts the electoral mandate. That is, we discussed that the people generally vote not for that particular candidate but for the party. And there is a decay to the trust of the people. There is subversion of the electoral mandate given by the people. So this is one impact that we see on the political stability. So defection fundamentally betrays the voter trust as legislators elected on one party's platform abandon their commitments for personal gain, ministerial birth, or even financial advantages. Okay. And the second impact is administrative disruption. That is continuous defections. It creates governmental instability, hampering effective administration and policy implementation during critical decision making periods. For example, as I gave the case study of a party having 105 and another party, ruling party having 105, and the opposition party having 95 representatives. If 10 people are switching, if 10 people from this party are switching to another party, to the opposition party, so what happens? There are chances that this party, the government led by this party, is going to fall. Now, when the government is falling, then this party has the chance of forming the government. And when a new government is formed, there is going to be a disruption in the whole administration. There is going to be instability in the governments. There is going to be hampering of the administration procedure as well as the policy implementation is going to take a very big hit. So all these things happen when there is defection. Another very important thing is this, if there is no anti-defection law, it encourages what we call as horse trading. It encourages what we call as horse trading. Horse trading. That is, defections encourage the commodification of legislators. That is, these representatives are brought and sold for certain amount of money, leading to what we call as commodification of legislators. That is, they will be given the promise of giving certain amount of money if they defect from one political party to another political party. And this creates markets for the political loyalty that fundamentally contradict democratic principles and ethical governance. So this is how the defections are going to impact the political stability in our country. Okay. Now, even though there has been anti-defection law to overcome the phenomenon of defection from one political party to another political party, this anti-defection law has not done what was exactly required from its side. So I'm going to give you a few instances that happened in the very recent past, which doubts the effectiveness of the anti-defection law. Okay, so for example, I already gave you the example of Goa and Rajasthan. What happened in Goa was that out of 15 MLAs from the Congress party, 10 MLAs jumped to the BJP, and they were not disqualified based on anti-defection. Similarly, what happened in Rajasthan was that in Rajasthan, 6 BSP MLAs, they merged their party with the Congress itself, making the number of representatives from BSP to zero and increasing the strength of Congress to, by six, increasing the strength of Congress by 6 seats. Similarly, what happened was that in Sikkim, 10 of the 15 MLAs of the Sikkim Democratic Front Party also joined the Congress, also joined the Congress. And another very important thing that happened in Manipur was that in the year 2017, shortly after the 2017 assembly election, seven Congress MLAs joined BJP, and one of them became a minister too. And the Congress party complained to the speaker to disqualify these 7 members on the aspect of anti-defection law. However, the speaker did not act on these petitions at all, saying that did not the speaker simply sat on these petitions, and finally the Congress party went to the Supreme Court, and in the year 2020, after 3 years, the Supreme Court directed the speaker to dispose of the matter within 4 weeks. That is, the Supreme Court said the speaker of the Manipur Legislative Assembly that within 4 weeks you should, give a ruling on this particular aspect of anti-defection. However, the speaker passed no order at all. Even after the deadline, the speaker passed no order at all. And finally, the Supreme Court had to interfere and used its extraordinary powers to remove T. Shyamkumar Singh, the minister who was concerned, from the cabinet and barred him from entering the assembly. So these things are happening even though there is anti-defection law. And another very important instance that I want to bring you is that what happened in Karnataka in the year 2010. So the year was 2010. So there were a group of rebel MLAs from BJP. And these BJP rebels, they rebelled against the then Chief Minister B.S. Yediyurappa. And they went to the governor to express their resentment against B.S. Yediyurappa's continuance in office and sought a constitutional process to be initiated. Saying that we are not supporting the government of B.S. Yediyurappa. The speaker subsequently disqualified all these MLAs. What did the speaker do? The speaker disqualified all these MLAs on the ground that their action in meeting the governor amounted to voluntarily giving up the membership of the party. So it all depends on the interpretation. So what did the speaker interpret? The speaker interpreted these rebel MLAs meeting the governor as voluntarily giving up the membership. Again, the matter went to the Supreme Court. And however, the Supreme Court ultimately set aside their disqualification on the procedural grounds, saying that they were not given sufficient time to file their replies and were not given advance copies of material relied upon by the speaker. So here, the Supreme Court had to interfere and had to protect these MLAs. Now, a very similar thing happened in the state of Tamil Nadu. What happened here was a group of AIADMK MLAs. They revolted against the then Chief Minister K. Palaniswamy in the year 2017, and they met the governor seeking a similar constitutional process against the chief minister. Now, what did the speaker do? The speaker here again disqualified 18 MLAs for voluntarily giving up the membership of the party. However, now here what happened was the Madras High Court upheld this disqualification. So what happened in Karnataka was, in Karnataka, the Supreme Court had set aside the disqualification. However, the Madras High Court, what it did, it upheld this disqualification. So there is certain interpretational mistakes with respect to this anti-defection. So the courts are also taking different steps. So there is no proper clarity with respect to anti-defection law. And another loophole that has been found recently with respect to this anti-defection law is something that happened in Karnataka in the year 2019. So what happened in Karnataka in the year 2019 was that there was a coalition government of Congress and JDS in Karnataka. So Congress and a regional party called as JDS had formed a coalition government in Karnataka. Now, what did certain MLAs from this Congress and JDS do was that they did not defect to BJP. Rather, what they did, they simply resigned from their post. Now, when they simply resigned from their post, can they be disqualified on the anti-defection law? The anti-defection law does not speak on this, does not speak anything on this. So what they did, they simply resigned on their post. And after the resignation, what they did, they jumped to the BJP. After the resignation, they jumped to the BJP. Now, after some time, or within 6 months, as the norm says, within 6 months, the election has to be held for the vacant seat. And within 6 months, the same MLAs, around 18 to 19 MLAs, who jumped to BJP, they contested the election from BJP and most of them won. And what happened was that BJP got the magic number to rule, or it got magic number to form the government. So there is no this is some loophole that is present with respect to the anti-defection law. There is nothing to address these loophole that is present in anti-defection law. So why I am giving you all these practical incidences to understand the challenges that are present in the anti-defection law. So there are some other challenges with respect to this anti-defection law, and the first one among this is party loyalty, blind party loyalty. Now, what is this blind party loyalty? That is, MPs and MLAs of a particular political party must follow party directions without exercising their independent judgment, potentially compromising their representative duties to the constituents. That is, the MPs and MLAs has to abide by the whip or direction given by their political party. They do not have a freedom of speech and expression. They do not have the power, or they do not have the luxury to act as per their conscience, going against the direction given by the political party. So this is a challenge that is present within the anti-defection law. That is, they have to abide by the party loyalty. The second is unclear time frames. Now, even though the anti-defection law says that it is the speaker or the chairperson who has to take decision with respect to anti-defection law, is there any specific deadline or timeline within which the speaker or chairperson takes the decision? No, there is no deadline within which the speaker or chairperson takes the decision. So what has happened is, many times this anti-defection law, let us assume if this anti-defection law, if this anti-defection provisions is with respect to the opposition party members, it will be taken very soon. But if it is with respect to the ruling party members, then it will be taken, in a very, very, very slow manner. And sometimes these petitions are not acted upon at all. And this is something that we saw with respect to what happened in Manipur. Ultimately, the Supreme Court had to interfere. And even though the Supreme Court interfered, the Speaker of Manipur did not act at all. And ultimately, the Supreme Court, using its extraordinary powers, had to put away or had to expel the minister from the cabinet berth. So, this is another issue with respect to anti defection law. Then, another thing is wholesale versus retail defection. Now, this anti-defection law allows for wholesale defection. That is, if more than two-third members of a political party agree to defect, or if they defect to another political party, then it is not considered as defection at all. Rather, it is considered as merger of the political party with another political party. Okay, but however, if just one or two representatives are defecting from one political party to another political party, then they can be disqualified. So what is happening is, this anti-defection law, it permits large group defection. That is, it permits wholesale defections while prohibiting individual switches. That is, it prohibits retail defection, thereby creating incentives for coordinated party abandonment rather than principled individual decisions. Okay, so this is another aspect. Now, then there is another challenge with respect to this anti-defection law, that is party formation loopholes. Now, what is this party formation loopholes? This anti-defection law says that if they defect to another party, then if they jump to another party, then the representatives can be disqualified based on anti-defection law. But what if these representatives, let us assume three or four representatives, if they form a new party itself, does the anti-defection law speak anything about this? There is nothing spoken about this. That is, for example, let us assume there is a state X, and there is 100 representatives from a party X. Okay, out of this 100 representatives, let us assume five, five, five MLAs, they don't jump to another party. Rather, what they do, they form a new party. They come out of this party X and they form a new party. Now, can they be disqualified under anti-defection law? There is nothing said about this in the anti-defection law. So, this anti-defection law, using this, politicians circumvent the disqualification by forming new parties or exploring ambiguities about national versus regional party definitions in the paragraph 4. Now, what is this national versus regional party definitions? That is, in the year 2016, there were certain MLAs from the party TDP. There is a party called as Telugu Desam Party. Okay, so in the state of Telangana, there were 15 MLAs from this party called as Telugu Desam Party. Okay. Now, what happened was that out of this 15, 12 MLAs defected to a party called as TRS, the then ruling party in Telangana, which is currently called as BRS. So then it was called as TRS. So out of 15, 12 MLAs, that is, if we consider two-third of 15, two-third of 15 is 10. So more than two-third, that is 12 MLAs are defecting to a party called as TRS. Now, ideally, more than two-third members are defecting. More than two-third members are defecting. But but the the problem here is that there is no clarity whether the original party refers to the party at the national level or at the regional level. That is, when 12 members of this party of TDP is defecting to TRS, what is happening is it is considered as TDP and TRS are being merged. But can this merger happen only in the state level? Because TDP also has its present in another state. So can this merger happen only in one state, whereas in another state, TDP acts as a separate, different entity. So there is no clarity on this particular aspect also. And the center or the crux of the problem with respect to anti-defection is the politicization of the office of the speaker. Because who is the deciding authority? The deciding authority is either the speaker or the chairperson of the upper house. Okay, so what is happening is that the speaker or the chairperson's office is being politicized. Why? Because who is generally the speaker? The speaker or the chairperson will generally be from the ruling party. So, do you think if there is an opposition party member being defected to the ruling party member, do you think the speaker or the chairperson is going to act against the ruling party and rule against the ruling party, saying that the person who has defected has been disqualified? That is not going to be possible, because in the present time, the speaker's office or the chairperson's office is highly politicized. So the deciding authorities, political affiliations can compromise the impartial judgment, leading to biased decisions in defection cases. So these are some of the challenges that are present with respect to anti-defection law. Another very important challenge with respect to the nominated member, the nominated member. Now, what does the provision say? The provision says that with respect to the nominated member, within 6 months, if the nominated member is joining a political party, then that is not considered as defection, or that is fine. But if the nominated member is joining a political party after 6 months, then that is considered as defection, and that nominated member can be disqualified under anti-defection law. So this is another challenge that is present with respect to the anti-defection law. Okay. Now, having realized or having understood about the challenges that are present with respect to anti-defection law, it is important for us to realize or to understand certain recommendations, or to go through the way forward or the steps that are required to reform this anti-defection law. Now, coming to this anti-defection law. Now, the first response or the first reform suggestion that is being given by the Supreme Court was that there has to be an independent tribunal system to look after this anti-defection law. That is, Supreme Court advocates for a specialized tribunal headed by a retired higher judiciary to ensure swift, impartial defection case decisions. Because currently, who is the authority to decide on this defection with respect to, disqualification with respect to anti-defection? It is the speaker or the chairperson. So the Supreme Court says that no, this cannot happen. This cannot happen. There has to be an independent tribunal headed by a retired Supreme Court judge, retired higher court or Supreme Court judge, to ensure that the decision based on anti-defection is taken, to ensure swift, impartial decision is being taken. So this is the first suggestion that is come. Okay. Now coming to the second suggestion. Now we know that with respect to disqualification occurring out of any other circumstance, who is the authority to take these decisions. The authority to take this decision is either the president or the governor at the national and at the state level, respectively. So, what do they say is that there is certain committees such as National Commission for reviewing the working of the constitution. So even they suggest that this decision making power has to be transferred from speaker to the election commission, and final decision has to be taken by the president or governor on the advice of election commission, as is happening in other disqualification cases. As is happening in the other disqualification cases, here also the decision has to be taken by whom? By the election commission. That is, election commission has to advise whom? The president in the national level, or uh, the uh, the president in the national level, or the governor in the state level. Okay, only then what can be done? The election, I mean, only then this defection can also be, the disqualification with respect to anti-defection can also be taken properly. Next, another recommendation given with respect to anti-defection is that its application has to be limited. Its application has to be limited. Now, what is this application limited? That is, anti-defection provisions has to be limited only to confidence motions, budget votes, and other stability determining parliamentary decisions, preserving individual conscience. Because what is happening currently? Currently, the political party is issuing a whip or direction to its members, saying that they have to abide by the decisions of the party. Now, while this is a good thing that the party loyalty can be upheld, but on the other side, what is happening? The members cannot represent their freedom of speech or expression, or they cannot vote or cannot speak as per their conscience. So there is another suggestion that has come forward saying that this anti-defection provisions should not be applied for everything. Rather, it has to be applied for confidence motion, budget vote, and similar stability determining parliamentary decisions. That is, any decision that can impact the fall of the government, that can impact the confidence of the government. Only for those things, this anti-defection has to be limited. Okay. The another suggestion that has come is that there has to be a strict time limit within which the authorities has to take up this particular anti-defection cases. So implement mandatory deadlines for defection case resolution, preventing strategic delays and ensuring timely justice, as emphasized in recent Supreme Court rulings. So either 3 months or 6 months, at least this timeline has to be given to the presiding officer, saying that within this time, the decision has to be taken with respect to disqualification coming out of anti-defection cases. Another very important thing, suggestion that has been given is the inner party democracy has to be strengthened. Now, what is inner party democracy? That is, the representatives from party or the elected representatives from the party has to be given the power or voice to give out their opinion. They have to be given the freedom of speech and expression. That is, the inner party democracy has to be strengthened to balance collective discipline with individual member representations, rights, and constituent interest. Only then the anti-defection law will have its true meaning. And I want to bring to your notice about a recent case, a recent incident that happened with respect to this anti-defection law. And this happened very recently in the year 2025 and in the month of August. Now, what happened was that few elected representatives, or few MLAs from the party BRS, they jumped or they defected to Congress. They defected to Indian National Congress. Now, while they defected from Indian National Congress, now from which party is the Speaker of the Telangana Legislative Assembly? The Speaker belongs to the party of Indian National Congress. So, even though BRS filed a petition with the Speaker saying that the anti-defection disqualification with respect to anti-defection law has to be initiated against these MLAs. Against these MLAs. So no decision was taken by the speaker, and BRS went to the Supreme Court. And the Supreme Court, in a case called as Supreme Court in Padi Kaushik Reddy case, Supreme Court in Padi Kaushik Reddy case in the year 2025, and in the month of August, said that Parliament must review the Speaker's role in defection cases and implement reforms to ensure anti-defection law operates both timely and fairly. So the Supreme Court is telling that the Parliament must review the Speaker's role in defection cases. So in other words, the Supreme Court in this Padi Kaushik Reddy case is saying that the Parliament must come upfront and amend the 10th schedule to review the speaker's role in defection cases. Either a specific timeline has to be given, or the speaker's role has to be made impartial and neutral, or this authority has to be taken from the hand of speaker and has to be given to either the president or governor, or at least to the Election Commission of India. So this is a very recent verdict came with respect to anti-defection law, and this verdict was given by whom? By the Supreme Court of India. So this is about anti-defection law, its provisions, its challenges, its reform measures that has been suggested.